Hello, everyone. Welcome to today's virtual roundtables on Asian law. Today's session will focus on Eugénie Mérieau's new book, excellent new book on constitutional bricolage. My name is Jaclyn. I am an associate professor at the National University of Law Faculty of at the National University of Singapore Faculty of Law, and the director of the Center for Asian Legal Studies. This book really, in a way, showcases some of the work that our researchers and the center has been doing, in the sense that it is a marvelous thing to see how this book has come about during Eugenie's time with us. Essentially, we have seen her go through blood, tears, and maybe some tears, a lot of sweat in how she's brought this book to its fruition. And the Center for Asian Legal Studies is very proud to have been able to support her in this particular journey. And so without further ado, I will hand the time over to Dr. Dian Shah, who will be moderating today's session and introducing the rest of the speakers. But before I go there, I wanted to say congratulations once again to Eugénie for this marvelous book that will no doubt generate many discussions about the state of constitutionalism in Thailand. Dian.
Hello and good morning, everyone from Singapore. Thank you for joining us in this 19th edition of the viral series, Virtual Roundtables in Asian Law, but it is also viral. Today's discussion will feature a recently published book, as Jaclyn mentioned, by Dr. Eugénie Mérieau, Exploring the Monarchy and the Rule of Law in Thailand. It is a great piece of scholarship. So again, congratulations, Eugénie, for publishing this book. Now, before we go into the introductions, I must thank the CALS team, especially Dr. Benjamin Lawrence, postdoctoral fellow at CALS, and Suguna Jagannathan, our manager, for putting all this together. The book that drives today's discussion, Constitutional Bricolage, is authored, as I said, by Dr. Eugénie Mérieau. She is an associate professor of public law at the University of Paris I, Panthéon-Sorbonne, and she is a member of the Sorbonne Institute of Philosophical and Legal Research. She was one of us. She was previously a postdoctoral fellow at CALS, and she is, as you know, or as you can see now, very much still part of the CALS family. So thank you, Eugénie, for your contribution. Our discussion today will start with Professor Tom Ginsburg, who is the Leo Spitz Professor of International Law at the University of Chicago. He also holds an appointment at the University of Chicago in the Department of Political Science. He is a research professor at the American Bar Foundation, and he holds a BA, JD, and PhD degrees from the University of California at Berkeley. Currently, he co-directs the Comparative Constitutions Project that runs an award-winning website called Constitute. His latest book is Democracies and International Law, published just last year, and he has authored an excellent book, I've read it myself, on how to save a constitutional democracy. Tom's remarks will be followed by Professor Andrew Harding, also one of us here at CALS. Andrew, thank you for joining us. He is a visiting research professor here and a leading scholar of Asian legal studies and comparative constitutional law. He commenced his career at NUS before then moving to SOAS, becoming the head of law school there, then to the University of Victoria, and then back to CALS. So he's really traveled all over the globe. We then will have Dr. Khemthong Tonsakulrungruang, who is a lecturer at the Faculty of Political Science, Chulalongkorn University. He earned an LLM from Yale Law School and a PhD from University of Bristol's School of Law. And his work focuses on constitutional amendment, law and religion, and judicial politics in Thailand. So he is one of the perfect speakers, or rather discussants, for today's event. And last but not least, we have Professor Thongchai Winichakul, who is an emeritus professor of history at the University of Wisconsin-Madison. Welcome, and thank you again for joining us. He's the author of Siam Mapped, a book published in 1994, and another book on Moments of Silence, discussing the massacre in Bangkok, which was published in 2020. His research interests are in the intellectual foundations of modern Siam under colonial conditions. Welcome to all the speakers, and we will start our discussion by having Eugénie give us a few thoughts about her book. Over to you, Eugénie.
Thank you very much. Thank you, everyone. So first of all, let me thank the organizer who have put this event together, and CALS as a whole. For indeed, I was a postdoctoral fellow at CALS when I completed the manuscript, and the center has supported me in many ways. I can say this book project was very much a CALS project indeed. So thank you, everyone, for your great support. I also want to thank the distinguished panelists. I'm extremely happy to have you all here today virtually, because your work, the work of each one of you individually, has directly inspired me to write this book. And as you probably have seen from the introduction and from the entire book, I directly engage with each one of you most relevant work, whether it is Tom Ginsburg's post-political constitution paper, Andrew Harding's handbook on the Thai constitution in context, Thongchai's many critical works on the rule of law, on the Thai monarchy, on Thai history, and Khemthong's work on Buddhism and constitutionalism. So I'm really looking forward to your comments and your critiques as well, which I'm sure will be extremely valuable for all of us. Now onto the book. Well, first, I want to start with this. I was told early on in this project that I should write the book I wanted to read. And this was a really good piece of advice, because indeed, when writing a book, you also have to read it and reread it and reread it again and again and over again. So yeah, what I tried to do in this book was to write the book I had always wanted to read about the Thai monarchy, a book that would not be driven by the compatibility question, meaning the question being, is Thai political culture compatible with democracy? A book that would not be driven by the convergence question or the reform question, which would be how to bring the Thai political system in line with Western models of democracy. Instead, I wanted to write a book that would dive into explaining, understanding, interpreting the extraordinary status of the Thai king in the Thai polity by giving the reader a layered description or an ethnographic account of the power of the Thai monarch on its own terms, based on its textual basis in the constitution, in laws, the underlying doctrines, and the conventions of the constitutional conventions accumulated over time. This was led me to question the very category of constitutional monarchy that we do have in constitutional doctrine today. And this category is very much under-theorized and shows us how we still have much more to do in constitutional law, and how countries outside of the Western canon can bring new perspectives into this question. Because today, the common assumptions remain that there are only two ideal types of monarchs: the figurehead British-style monarch, which is characteristic of a democracy, or the opposite, which is the hands-on ruling king of an unnamed Gulf monarchy, who's head of state, head of government, and who rules an authoritarian regime. So the former, the British-style monarch, is fully constrained by the rule of law and the principles of constitutionalism, while the later, so the hands-on ruling king, is arbitrary and unfettered. But the Thai monarch, like many other present and past monarchs and presidents, does not fit into either category. And my point is actually that the British style monarch doesn't fit into either category either, and also the hands-on ruling king. So the phenomenon of monarchy is framed in oversimplified binary terms, and this is really problematic because as a result, there is little political analysis of the monarchy, the British monarchy, or the model of monarchy, because political science studies power and the Queen is supposed to have none. And there's also little constitutional analysis of the ruling king, because law studies constitutional norms and the ruling king is defined as being ruled by constitutions, but without constitutionalism. So the shortcomings of the binary are very much self-evident. The British Queen does have discretionary reserve power, and the constitution of the ruling king does exercise some constraint on the monarch. And therefore, it is important to deconstruct both categories in order to understand the Thai monarchy. And that was precisely what my aim was in this book. At the time of writing in 2021, now we're in 2022, the doctrine of constitutional monarchy, the model doctrine, is still entirely tied to the experience of the British monarchy. It's particularly outdated. It's anchored in the 19th century writings of Peixoto and Taisei and Jennings. And therefore, we need to rethink all of this together. In particular, the formula that is very much in use in Thailand, that the Queen or the King has a right to be consulted, to encourage and to warn. And this remark, which has had a remarkable and unexpected fate by becoming a self-fulfilling prophecy, is now invoked by monarchs all over the world, including very much so in Thailand, and used as a standard to measure whether or not the constitution matters in monarchies. And I want to challenge that basis. If we still talk about the British model of constitutional monarchy, we can define it by one main convention, constitutional convention, which can be summarized as follows. The monarch, acts on ministerial advice, with ministers being responsible to Parliament. Today, it is accepted that the British monarch retains reserve powers, whereby he or she has discretion to act in the absence of ministerial advice or even against ministerial advice in specific circumstances. However, the extent of those reserve powers and the identification of the circumstances that warrant their use is very much disputed. For instance, Anne Tuomi identifies the following reserve power: the power to advise the government. So we have the Peixoto formula here: the appointment of the prime minister, the dismissal of governments, the power of dissolution, including the power to refuse or to force a dissolution, the summoning of parliament, the power of granting royal assent to bills, including the power to delay or to refuse assent to bills and to suggest amendments to bills, and the rejection of advice to act when it is illegal or unconstitutional. So most scholars argue that these reserve powers are still in the British common law. And even though they are not used in present-day UK, it means that they have succeeded, because the very principle of these powers is that they should not be seen to be used. So in the British model, in the model that we have of constitutional monarchy, the reserve powers ought not to be used formally. They should not be seen to be used. But if we go back to Thailand now, the question of the distinction between the legal versus the informal, or the constitutional versus the conventional, is used as a criteria to assess to what extent the Thai constitution matters or not. So even though the very idea of the reserve powers is that they should be used informally, So that's where we do have some need for more theory here. So the question being asked about Thailand is the constitution truly the supreme law in the land? Is the king truly constrained by the constitution and the rule of law? And this is a question that frames much of the scholarship on the Thai monarchy. And I argue that in this question, we actually see how there is an over-idealization of the Western model of monarchy and a mirror over-depreciation of the Thai model of monarchy. So in short, if I summarize, this book is an invitation to rethink and refine the category of constitutional monarchy, to look at how it is defined in relation to constitutionalism and the rule of law, which are categories that are culturally informed, and in particular informed by religion, by Buddhism. And also, besides the question of the monarchy, I tried to make other contributions in this book, a methodological contribution on how to research constitutional polities, foreign constitutional polities, by looking at bricolage, so how the polity is based on legal transplants whose meanings have been shifted by the various local actors, local legal actors. Another method linked to bricolage is layered description or ethnographic account of polities. So the idea here is to write a monograph about a foreign constitutional system by deconstructing it layer by layer, starting with text first, so constitutional text, law, then moving to doctrines, and how they're informed by religion, by cultural categories, and then looking at practices or how the constitution is being interpreted in that specific context. So that would be my methodological contribution, bricolage and layered description. Then there is obviously the epistemological contribution. So here the idea that established universal or so-called universal categories such as the rule of law, constitutional monarchy, constitutionalism are idealized in the Western canon. And as a result, rather than assess non-Western countries based on their performance related to these categories, we should use the study of non-Western countries as a tool to question and refine these very categories. And finally, there's an empirical contribution. So I try to document what the rule of law means in Thai constitutional discourse, how it is informed by doctrines of Buddhist kingship, and how these conceptions have evolved from the mid-19th century until now. My hope with this work is that I support attempts to deconstruct the Americano-Eurocentrism of the discipline, which are still built partly on derivatives of the modernization theory. And also it is the ambition of this book that the concept of bricolage and the methodology of constitutional ethnography offer tools to comparative constitutional law scholars around the world who are eager to study the sophistication of constitutional phenomena outside the West, regardless of whether or not they conform to specific Western models. So thank you very much for your attention, and I'm looking forward to your comments.
Thank you, Eugénie, for a very concise explanation of your book, and in particular its aims and methodology. Now we go on to our first discussant, Professor Tom Ginsburg.
Thank you so much, Dian, and thank you, Eugénie. You said, this is the book, you wrote this book because it's the book you always wanted to read. And I have to say, it's the book I always wanted to read and could never have written. So I'm really impressed with it, and I learned so much. And I think you've really advanced the study of Thailand in general, in English, by exposing essentially all these debates in political and legal theory over 2 centuries. It's really invaluable. I always say that Thailand is kind of like the platypus of countries, the the platypus is that animal. It's not a marsupial. It's not a mammal. What is it? And Thailand's kind of like that too. It's neither too authoritarian, but never very democratic. It's very low variance, but it's always changing. And I think you've showed us that that's true of not just Thailand, but the Thai monarchy, I would say. And also true, of course, of Thai political theory. I mean, really, it's incredible how you show that just there's this very flexible, very supple borrowing, if I can use that term, I don't want to load it, but bricolage, right, of gathering whatever's available as it comes up in around the world, and then deploying it in very contested ways, right? So it's not as if there's always just one actor that's choosing. There's all this discussion, but there's a framework in which that is all brought together into a single kind of construct. So I think it's really extremely interesting and valuable. So I have three sort of comments. Well, I don't know. We'll see how many comments I have. So first I want to make a comment about, so the platypus idea, of course, is this democratic regime with the king as head of state. Like, what is that? And I think you've showed us that in some sense, even the words, the categories that we try to, describe that, where is sovereignty in some, that's not actually the question at all. Sovereignty, almost, you could just take sovereignty and never use the term in Thailand, and I think we'd be fine. People deploy one or the other. Oh, it's the both shared sovereignty or whatever, but those are really forms of argument that are being made that don't, in the end, I think, have much consequence. They're rather consequences of struggles that have occurred, in other places, informal struggles, and then the discourse kind of gets deployed on top of that. So there's this kind of deep stuff underneath that's really driving things. I came away thinking that, Thailand's not a constitutional monarchy. It might, though, be a constitutionist monarchy. And what I mean by that? And constitutionalism is the idea that there's constraint from the Constitution. And that's clearly not the case. And yet, the monarchy and the system is always deploying these constitutions, right? And not really as constraint, but is doing something with them. So it's the idea that the Constitution is almost like a semiotic or something for some deeper and invisible power struggle. And I came away revising even my own prior understanding. I'd always thought, well, there's constitutions and then there's this unwritten constitutionalism underneath. And now I'm not so sure. I mean, I don't think you don't really describe many unwritten norms. There is an unwritten institution, which is you're going to have a king. But then within that, I don't see much constraint. So I really feel like you've problematized a lot of different categories. So two really interesting themes that you bring up, and then I want to talk about trying to put it into comparative light. So one theme, which you're not totally explicit about, but that legal knowledge itself is constructed in this milieu. And, the fact that there is a monarchy is the basis for all this legal argument that's going on. It could be done in religious terms, but it's done through law. And that's obviously kind of epistemic community and expertise. And in that world, in those debates that are going on, you see different moves being made where it's almost like the monarchy is like the sun, and there's gravitational pull of all the legal arguments that are being made. And different people, maybe sometimes outsiders, right? They don't, at the beginning, they're all princes in the 19th century, but eventually they're outsiders or, let's say, not central by virtue of biography, but they're able to make these moves and kind of get a little closer to the system by deploying various forms of monarchist, legal arguments. So I thought that was really interesting. Even what you describe at the end as juristocracy, I believe has that quality. So I don't think juristocracy is quite right here. Juristocracy says, there's already kind of a law out there, and, well, we're going to expand its role in order to preserve, power. And I think, I don't know, I mean, there's an element of that, but the way I see the developments of the last couple of decades, they were a little more contingent, but that the single event I have in mind, which is actually a decision the Constitutional Court made to allow Thaksin Shinawatra to run back in 2001, I believe. when he was convicted of, he had some corruption charges. And they made the decision to let him take office as prime minister. And, you know, that wasn't juristocracy, that was law. And yet then in the subsequent 2 decades, we have seen, and you have described, you know, the pull of that, of those institutions to being really, you know, very conservative and very much limiting the space for political contestation. I guess the point I'm trying to make is that legal knowledge, you know, is sucked into this kind of gravitational field, if you will, even without, you know, it being sort of constructed that way to begin with. So I think it's slightly different than Ron Herschel's story. Okay, let me say what I think. I'm not so sure that you blow up the category of constitutional monarchy for everyone and everywhere. I'm not yet convinced of that. I'm doing a lot of work on constitutional monarchy now. I haven't shared any of the work with you, and I want to, as you know, we've been talking a little bit about that. But I think when you look at monarchies all over the world, there is a kind of framework one can see that's very simple, and it's about basically bargaining. The king's bargaining with society. And that's, of course, a classic story of the English monarchy and how through myriad iterations, they lose their actual power, but maintain the crown. And eventually they have no power, but they still play a role in the society. And I think they play 2 roles, even with no power, constitutional monarchs. One is what you talk about a little bit, which is what I call crisis insurance. Like when there's a crisis, we don't really know where it's going to come from, but the monarch might have to resolve it. And Twomey describes that in terms of reserve powers. I don't know that we need to use that language generally, but the function of having a powerless person being able to provide focal points is a good one. And I think one that we see, and monarchs that survive play that role. The other one you don't talk at all about, which is the role of monarchs in integrating diverse societies. And I think when we look around the world, we see those surviving monarchs. They're often defending minorities. They're often allowing a channel. I suppose you could say this is true in Thailand in terms of allowing particularly, you know, ethnic Chinese ties to sort of signal loyalty. But you don't talk much about that function, maybe because this is not really that kind of powerless constitutional monarchy. So it's not appropriate to think about in those terms. But I think we can still generalize. I wouldn't blow it all up and say, well, we need to just, you know, do constitutional ethnography everywhere. There are patterns. And one pattern in particular I'd like to mention is that of this bargaining, which at some junctures, some moves that some kings make means that the monarchy ends, right? And that's the history of all the republics in Europe in the 19th century. It's the history of some of the Arab republics. That does happen. So I think the key moment here is 1932, of course, in Thailand. That's the nadir of monarchic power, the lowest point of monarchic power. And in some sense, there's a kind of contingent feature which allows the monarchy to survive and regain its footing, which is, I think, that maybe one interpretation would be Priti Banomyong wasn't a very ruthless person, or that the People's Party was divided. I'm not quite sure, but I do think we shouldn't just accept the deep Hindu Buddhist idea that the king is always going to be there, that there is a bargaining process that can be described in fairly simple terms and compared across countries. So that's one methodological point I'd like to make. The other point I'd like to make is that I think you don't bring this theme out, but the book really makes a really interesting point about what I would call the materiality of these constitutions. So is it Rama VI who has this, you know, toy constitutional order, toy country he creates? Wow, that was the most fascinating thing I'd ever read, like a play country, a play constitution. And then you've also written about, of course, the display of the 1932 Constitution with using Buddhist kind of imagery as like a sacred object, almost like a relic, a Buddhist relic. So that material dimension, I mean, I haven't seen anything on that generally. And that, I think, is something that you invite other constitutional ethnographers to go and try to explore that theme in other contexts. So, okay, that's a bunch of somewhat random comments, but the bottom line is this: I think it's really a great achievement, and I've got my electronic copy is all marked up with things I want to, you know, cite everywhere, and I'm really grateful. So, bottom line, everyone should go buy and read this book if you want to understand anything about Thailand.
Fantastic. Thank you, Tom, for your really insightful analysis of the book. We now invite Professor Andrew Harding to provide his comments.
Thank you very much, Dian, and sorry to hear that Eugénie is having to stay up so late at night for this, but you know, that's a tribute to your commitment. And first of all, I mean, huge congratulations on a masterful work that I think really, almost really transforms the field of looking at constitutions in Thailand and looking at monarchies in general, and particularly across Asia. And I want to say a little bit about that. This book has been long expected, long awaited, and huge congratulations. I think it immediately makes Eugénie a leading scholar in this area. And I think we can expect that everybody who wants to know about anything about Thailand is going to have to read this book. And that's going to be true, I think, for a very long time to come. It's an incredibly rich study. It's incredibly comprehensive, and it's also incredibly well written. I mean, it's just a really fascinating, interesting read from every point of view, whether you agree or not with everything that is being said. So in terms of an ethnographic study, it's hard to imagine anything that would be really quite as rich and quite as granulated as this study is. Now, there's a danger in these things that we may overlap in our comments, and I actually agree with a lot of what Tom said, although I'm going to disagree on one point. But his mention of Thailand as the platypus brings to mind to me the fact that it seems every time I go to Thailand, people will ask me this question, you know, do you think that Thailand is unique, or is it an example of general phenomena? And I think that's a really interesting question, and it's really great to get their views on that. I usually give a kind of a platypus type of answer to say that, well, you know, it's unique, it's yes and no. It's unique in some ways, and in other ways, it's an example of a general phenomena. But I think this is a great question to think about. So in this book, we have this, you know, incredibly detailed and rich and comprehensive account of the monarchy in relation to constitutionalism in Thailand, and it's wonderfully informed by different disciplines. So it's a really deeply contextual analysis. And obviously in doing that, it tends to emphasize the uniqueness of the Thai story. The difficulty that one finds with this kind of study, and contextual analysis is what I've always tried to do in my work, is this kind of little gremlin in the system that pops out when you've done your work and asks the terrible question, so what? And so there is this danger that one might be accused of kind of constructing this big cloud of facts, and it may be fascinating and rich and detailed, but people are apt to say, but for those who are not specially interested in Thailand or wherever it is, what do you have to learn from this study? Now, I'm glad to see that Eugénie has clearly addressed this so what question in the book, as I think you have to do. And so instead of simply thinking about Thailand as sort of the other to some kind of Western model, we take it seriously in its own terms. And that in itself is, I think, very instructive to comparative lawyers who look at constitutions. But we have to try and see the relevance of a study of this kind to constitutional systems in general. And here we find that Eugénie gives 3 interesting answers, or really perhaps 2, because I think numbers 2 and 3 about legal transparency and bricolage are kind of deeply connected with each other. Now, Tom's discussed the issue of constitutional monarchy, and I wanted to say a little bit about this theme. I have always thought that the category of absolute monarchy really made no great sense to me. And especially, I think, if you look at the monarchies in Asia. So unlike Tom, I am totally with Eugénie on trying to abolish this distinction between absolute and constitutional monarchies. And in my own work, I've talked about Nasrinian monarchy in Malaysia, for example, which is another of those monarchies that doesn't really speak either to absolute or to constitutional monarchy. Incidentally, I mean, for the benefits of the audience here, you may be interested to know that Eugénie is part of a special issue that I'm doing on monarchy systems in Asia, together with Matthieu de Visser. And in our introductory article, we actually make exactly the points that Eugénie makes about constitutional monarchy and about legal transplantation and about constitutional bricolage. I may add that we did this without reference to the book. We only discovered this process of reasoning after we put our article together. It's interesting that we reached the same points and actually in the very same order, with the exception that instead of constitutional bricolage, we talk about constitutional métissage. So, you know, French seems to be a language which comes up with some very, very interesting words to describe some of the things that we find difficult to convey in English. And on the subject of language, I think, you know, one of the great things about this book is that it's being published in all three languages, in English and in French and in Thai. And I think that's a wonderful thing that will make sure that it reaches the widest possible audience. So particular congratulations, Eugénie, on that. So we are with Eugénie in terms of trying to find a way past this kind of binary of constitutional monarchy and absolute monarchy. One of the difficulties with this issue, of course, is, and I think this is hinted at in what Eugénie said as well as what Tom said, is that even so-called constitutional monarchies rely on informal mechanisms, and therefore you cannot use the written constitution as a way of distinguishing absolute from constitutional monarchies. And from that point, the relationship between these concepts becomes so muddy that you finish up having to abandon both of them. So I'm very much with you on that. The book also tries to re-problematize the idea of legal transplants by substituting the idea of constitutional bricolage. And this is very similar to what Matthieu de Visser and I do in our article, with the idea of constitutional métissage or braiding of constitutional ideas, which, as I read it, looking at how Eugénie talks about this, I think we're exactly on the same page with that. So apart from matters of complete agreement, I wanted to come on to possible disagreements. And in the book, Eugénie takes me and Peter Leyland to task for distinguishing the constitutional from the extra-constitutional, with reference in particular to the monarchy and the military. So in her view, we do not, and we should have followed through on the idea of a division not of three powers, executive, legislature, and judiciary, but a separation of five powers incorporating the monarchy and the military. This is an idea that we discuss in our book, but I have to give credit to Kevin Tan for originally drawing this to our attention at a seminar in Bangkok. And on reflection on this, one might even say that there's a sixth power, thinking of Mark Tushnet's recent work, namely the independent agencies, which are very important in the Thai system as they are elsewhere. Now, what brings what this brings to my mind, this discussion about what we mean by constitutional and extra-constitutional, is the problematic of the word constitution itself. This is particularly difficult in Thailand for two reasons. I mean, one is that obviously there have been 20 constitutions, and so what does the term constitution actually mean in this context? But even more importantly, because of our understanding that the text itself may not capture everything that is constitutionally salient. And so this is the difficulty. How do you capture this in terms of terminology? Leyland and I, in our book, use the idea of a constitutional system. So whereas other books in our series talk about the constitution of XYZ country, we talk about the constitutional system of Thailand, and we engage in contextual analysis, not at the same level as Eugénie. His discussion is much deeper and more wide-ranging in a way than ours, but we attempt to engage in that kind of analysis. So in what sense do we then use words like unconstitutional or constitutional or extra-constitutional? We deliberately, and Eugénie asked me to address this, so this is why I'm talking about it. We deliberately use the term extra-constitutional rather than unconstitutional. But I might add here that I think many people in Thailand might say that things like military coup should be described as unconstitutional rather than simply extra-constitutional. But anyway, by choosing extra-constitutional, we indicate that the written text of the Constitution does not accurately describe that which is regarded as legitimate, namely the exercise of military and royal power. Now, arguably, as she says, we could have devoted more space to those elements, but we certainly don't ignore them. But I think she's made an interesting point that we would take into account if we get to the point of doing another edition of the book. But let me also mention in this connection that, of course, since we wrote in 2010, it's a long time ago in terms of developments in Thailand. And I think things look very different now from how they looked back in 2010, where along with Tom's work, we talk about the constitutional afterlife of the 1997 Constitution. How far in the past does that now appear? So the arguments about separation of powers, the trias politica, now have receded somewhat into the background, but perhaps only for the time being. Things can change again. And in this connection, one of my main sort of fear really about the book is that it might be perceived to be insufficiently critical of the system that it's describing. And Eugénie criticizes scholars who are cynical about Thai constitutions and about the constitutional court and so on. Well, point taken that we have to, in these exercises, in terms of the methodology of how we approach these studies, suspend our disbelief. And in our book, the same as Eugénie, we try to take the Constitution or the constitutions seriously in terms of text as far as we possibly can. But I suspect that there are a lot of people, including, I heavily suspect, people in this very room, who might actually express some of the views that Eugénie describes as cynical. So I think when we take account of the internal perspective on constitutionalism, we have to take account of the critical internal perspectives as well as the dominant ones. when we talk about constitution, and I am going to wrap this up, Dian, pretty quickly, don't worry. When we talk about constitution in Thailand, what is it that we talk about? And here there's an interesting passage, which I agree with in Eugénie's book, where she says, first, the methodology, the approach must adopt an extensive non-formalistic definition of the constitution, which includes, but is not restricted to the master text bearing the official name of constitution, the big C constitution. The problem, of course, is how do you get to the little c constitution? Such definition must be inclusive of the statutes, administrative regulations, doctrines, judicial interpretations, and conventions, whether codified or uncodified, written or unwritten, justiciable or not justiciable, that regulates the operations of the highest organs of state, and so on. So that passage describes exactly, I think, how one should go about this, although it could theorize a bit more about the terminology that we might use and what it might mean to describe things. So there is still this ambiguity of what we mean by constitution in a system where the written text very clearly doesn't tell you anything like the whole story. Where do we go? Where exactly do we go from that? And when we use terms like unconstitutional or extra-constitutional, what is the constitution outside of which or contrary to which such things are? Now, if we take the idea of a constitutional system, then I think it becomes rather clearer. With regard to the actual text of the Constitution, one thing, of course, that this approach would entail would be looking not simply at the text of the current Constitution that is in force, but the text of all constitutions that have been in force. And I think what this leads to is trying to find, which of these elements, which of these texts even, remains there in spite of all the constitutional changes. And I think that's a very valuable exercise. I found, for example, that the text on emergency powers has remained pretty much unchanged ever since 1932. So the idea that you completely overturn the constitutional order when you have a military coup and so on, not necessarily absolutely correct. So this approach is really excellently carried through over 11 chapters in the book. And I think there's so much to learn from this book that I really look forward to engaging even much further with it. And once again, Eugénie, congratulations on a really wonderful book. And it goes beyond even what we hoped for and we expected in terms of it raising issues that even those people who don't necessarily work on Thailand would still have to think about. Thank you very much.
Thank you, Andrew, for your rich comments and critique, and also drawing this comparative perspectives from other jurisdictions in Asia, Malaysia, in particular when we talk about the monarchy. Just a reminder to the participants, if you have any questions either for the author, Eugénie, or any of our panelists, please type them in the question and answer box. Okay, so from the US with Tom to Malaysia, where Andrew is, we now fly up to Thailand, and we have our third panelist, Khemthong.
Thank you very much, Dian. And to Eugénie, first of all, congratulations. I have read a lot of your works before, and I can see that in this book, all your previous works on the compromise of the 1932 Constitution, the Buddhist constitutionalism, and the deep state, and so on, have finally come together into this very well researched and richly detailed work. So I talked to a few of my colleagues who had read it, and the feedback is very positive. Everyone is so excited with this book. Actually, I think everyone agree that this is one of the most exciting book about Thai constitutional system or constitutional law in recent years. We couldn't think of anything like this apart from like in 2010 with Andrew Harding's and Peter Leland's book on Thai constitutional system contextual analysis. So that's a big thing. And as I read into the book, I am very excited to learn all the historical debate and evidence. And I mean, this is not something we normally read in the law school, and you have endeavored to show us. For example, you have put things in perspective. The three kings, King Chulalongkorn, King Vashiravut, and King Prachatipo. The three of them all played and toy with the idea of constitution in the different ways, but all of them has at some point in their office considered about getting a written constitution, and all of them never given one. And when you connect all these dots, and you see that they are leading to the 1932 revolution indeed. So that's something that I really love about this book. This is an example of finding and understanding what I would like to call an indigenous model of constitutionalism. The very Thai things. What exactly is the Thai constitutionalism? And each chapter could be expanded into a book of its own, really. A lot of interesting details that worth further exploration. But this richness means that I have to pick only some parts to discuss here. And please consider this to be a conversation to your book in relation to my own work and on Buddhist kingship. So as I say, this is a rare contribution to Thai constitutional studies. Most Thai scholars would assume that with the cycle of coups and elections and a rapid constitutional turnover, that means each coup has severed any connection between the current constitution and previous constitutions, and therefore we are often very busy chasing the current law. So that's what happened in current law schools. In the con law class, that's all about the current laws in effect. To understand that article and this article, the new constitutional system, the new electoral system, the Senate, and also on and so forth. And unfortunately, most of the time, once you graduate, whatever you learn from the con law class become mooted. We already have a new constitution. So I mean, this utilitarian approach is understandable. We are the law school. We train lawyers. We teach what is in effect and something that the student can use when they enter into profession. But at the same time, this mentality leaves very little room and opportunity for con law students to explore further, to see things in larger pictures, and to realize that there's some connection, although afterlife might be inadequate here. But if you go through history, constitutional history, you see that actually there's trends and patterns, as Eugénie has shown, like the arrival of the idea of constitutionalism, the arrival of constitutional justice, the arrival of the military idea of constitution. So there's pattern, there are trend, and that would lead you to a better understanding. That's something that Thai law school fall short of doing so, of delivering this. That means the subject of Thai constitutionalism, especially the subject of the monarchy and constitution, is vulnerable to voices of very few prominent scholars to dictate the narrative. The so-called, you call it the Chulalongkorn school of thought, something like that. And that's something that I find very fascinating, that throughout the whole book, you see only few names coming up. It's Dicey, it's Lord Denning, it's Walter Bagehot. And that's only 3 names that keep coming up throughout the whole 80 years of all these debates. And they are mentioned in the way that is as if they are dogma, their teachings are dogma. There's no follow-up on critiques of their ideas or reflection on whether it's applicable or accurate or not. They are regarded as dogma in Thai constitution. And that's the influence of those few voices from Chulalongkorn school of thought. And that's so unfortunate. So that's something. So as I say, most readers' feedbacks are positive. At first, there would be some confusion, some complaints that there's no theoretical frameworks, and it's so confusing with different ideas and this and that. But I think that is what bricolage is. I mean, there's no like single idea that flow through all the 11 chapters. In this chapter, you learn about this idea that we adopt and that idea and different one. So some readers find it confusing at first, but I mean, no one would disagree with your main statements and thesis. And the layered methodology, I think that is skillfully applied when you retell the same events through different perspectives and point to different things that happen, different ideas that you identify. And this book covers the entire history of Thai constitutionalism. So that's over a span of 80 plus years. And despite the great volume, still, I think Eugénie has to move at a very high speed to cover everything. So some details might not be sufficiently highlighted in my opinion, but there's a trade-off for like being comprehensive here. So it might be a little difficult if you don't have background in Thai political history. For example, the event of 6 October massacre, the leading up to the event, the Black May massacre in 1992. But overall, I don't think that that impacts so much on the value of your book. It's just that people have to look into the reference and work a little further. But also I wish to know more about those names and explanation of why they act in the way they did. For example, I find it very fascinating that the military has turned from the one who overthrew the monarchy into a very loyal guardian of the throne during Sarit, Field Marshal Sarit. So there's a big question if someone who is not familiar with Thai political history, they would ask like, what happened to the military during that period that they become like they switched side. But there's a lot of tellings and showing that Eugénie has done excellently. Of course, I wish to hear more of your own voice about some ideas represented in the book. For example, the idea about the debates about the king's prerogative. A few names, those Denning, Dicey, and Bagehot, whether that's the accurate presentation of their actual idea, or it's just what we call abusive borrowing, just borrow the name and put anything Thai into their liking. The final part of my session here is on the idea of Dhammarāja. That is a very Buddhist kingship. That is a very prominent idea that is present throughout the book. The whole book for me is all about how the Thai theory of monarchy embraces new ideas and adapt their new identity while still preserving its core substance, the king's superior position and prerogative. And this book shows Dhammarasha's strength, the ability to negotiate with new ideas and survive, even like at the lowest point in 1932, through the work of two very genius kings, King Prachatipak and Bhumibol. They are able to revive the former glory, and I would say that become even more glorified than during their absolute monarchy time, really. So that's something that very fascinating. Also, I mean, there's some limitation, understandable, that we cannot fully discuss the failure of this idea as much as we do on the strength of it, right? Dhammarasha is not coherent. You can spot variants of it, and some variants, like the great elect variant, that people pick the king. The kingship is not hereditary. People choose one perfect man to rule over them for peace and order. I mean, it has potential to be developed into a democratic kingship. Others, such as the world conqueror, the idea of Chakravartin, the king of the king or the lord of the lord, the universal monarch, is able to turn every act of modernization and developments into the king's ancient traditional meritorious missions. The act of giving a new constitution is not an act of modernity. It becomes an act of, like, it's become a benevolent act of Buddhist king to provide his subject with a better articles for governance, right? As well as other benevolent acts, the intervention of the massacre, combating insurgency, or giving the idea of sufficient economy throughout the time of economic crisis. Of course, it has to omit a few instances where the king acts in a less democratic manner, such as events leading up to 6th October massacre and toward the end of Bhumibhol's reign. Right. But Dhammarasha would need to be developed further, were it to be able to coexist with some form of liberal democracy. Dhammarasha is no different from the divide kingship theory in the Middle Age Europe, where the king's power is supposed to be constrained only by God. His power is unlimited except by God's purpose. Thai monarch's power is restrained by his Buddhist Dhamma. But the question remains that even Thanin Kraivician or Bawan Sakuwanos, those who spearhead the idea of modern theory of Thai monarchies, couldn't answer of how to hold the king accountable. In Dhammarasha theory, no subject can hold the king accountable, since doing that would upend the political structure, the king at the top or the subject below. In the ancient belief, this problem is solved because the king will be punished by, like, losing the throne to another contender or this natural disaster before his kingdom. But the modern theory gives no such satisfactory answer to that. A regicide is unthinkable. A revolution is unthinkable when it's against the idea of constitutionalism. So the importance of the failure shouldn't be with what the king can do at his best, but what the people can do at His Majesty's worst. And that's something that all these scholars fail to answer satisfactorily. The king's best answer is to thee have I sinned. So he will exercise his power in the benevolent manner for the benefit of the people, but he's not accountable to them. He is accountable to Dhamma or something higher, universal law, celestial law of Dhamma. And that's insufficient in a democratic polity. I mean, that perhaps we must look into authoritarian constitutionalisms and how, like, in works of maybe theory and works on Asian constitutionalisms, how people under authoritarian regimes negotiate the idea of constitution and accountability with the authority. And the book ends at the very critical point of Thai constitutional history when the bricolage is putting to the test. The new king Chulalongkorn doesn't follow all these conventions, which themselves has lost their charm to the younger generation. And to observe Chulalongkorn's version of constitutionalism would be like the next very interesting project for any scholars on Thai legal studies. Thank you very much.
Okay, thank you, Khem, for your, again, another rich and insightful critique and set of comments. Now to our final commentator or discussant. Over to you.
Thank you. I'm having trouble right now being the last speaker because I'm confused. I mean, my head is spin with all the previous comments, mix up what I'm about to say because I prepared something, but the more I listen, interesting point here, interesting point there, and I'm getting lost. Okay. Let me start from truly congratulating Eugénie. When I read the text, in a way, I'm not trained as a legal scholar. In a way, it's helpful because I think I can understand the text of the book. At the same time, the text of the book brought me outside the text. I mean, took me away from the text. Think about politics, think about history, think about even like, I just finished an article unrelated to legal history, nothing. I finished I finished an article on the royal rituals, on rationalism. So I can't help like reading this book and then thinking about what I just finished. So then the book brought me into many directions. And when I realized, wow, that's great. A good book is to have a dialogue, to have conversation with so many, I mean, people from so many directions. I think this book has achieved that, at least in me, whose interest is a bit chaotic. I can see the book talking to me politically, talking to me in terms of legal history, talking to me in terms of Buddhist studies, talking to me in about modern history. And to some extent, theoretically as well. When you say that, okay, my first set of questions, I like the idea of bricolage a lot. I like the idea a lot. When you say that you try to get over or overcome the binary in terms of definition for the constitutional monarchy, I see another binary that Thai legal history has been struggled with. Speaking as a legal, I'm not trained as legal scholar, so I can see this binary. So if I'm wrong, just forgive me. One of the legal history, Thai legal history argument is that why we become the court law instead of common law, right? Very simple. When I see the bricolage, I'm happy. I kind of, yeah, finally we have something else, not common versus court. Don't you think, is it an idea that could make this book relevant? Could make this book's relevance into different directions? You mentioned constitutional monarchy. I'm thinking about legal system. On this point, everybody else can help me or correct me or whatever. We often look at Europe, court law, okay, court system and common law system. But when you look at the colonies, when you look at colony legal system in colonies, None of them are purely common law or purely court law. No, I'm not sure it's to the extent that legal system in colonies are bricolage or not. Maybe not that level of chaos, or not that level of improvisation, taking things at hand to mix together. Yet it is a kind, to some degree, a kind of mixture for sure. The point is that, do you think constitutional bricolage in the Thailand case reflect or originate to some extent or to a great extent from a mixture or bricolage in the legal system? Or do you think Thai legal system, I use the word legal system in a broad sense, because we know it is a court law, but you look at the way I just read the documents in Rama the 6th, Rama the 7th, the system they train the judges in Rama the 6th, Rama the 7th. They're all by common law system. It's court law, but the training in the first 20, 30 years of judges in Thailand by British judges, by Prince Rapi, who is common law by training. Then we look at other things. I think it's a kind of very mixed. Even though one article in Andrew's edited volume recently talk about how excellent the British judges are. I know they're excellent, but don't you think it's a kind of mix? Then if constitutional bricolage reflects the bigger picture of the bricolage of the legal system, then the next question is, don't you think to some extent, legal system in many other colonies also a mixture? I'm not sure to the extent that you can call bricolage, but if it's true that the kind of mixture, even in Singapore, it's interesting to see that this constitution, this issue in the Thai case constitution, somehow bring the relevance of this book to a different direction, to talk about, hey, maybe we have another, instead of binary between common law and court law, we have a kind of mixed legal system as a third category. And with the spirit of post-colonial studies, post-colonial legal studies, I think why not take a bit courage, hey, we propose a third category instead of common or court law. And this is the majority of the world we call colonial legal system or post-colonial legal system, that maybe your book is talking to other countries, to other cases in this direction as well. But to take to this direction, a few more questions emerge. If Thailand's constitutional bricolage somehow reflect the mixed legal system, why the phenomenon you talk about, you tell us the whole book, is really bricolage, is really chaotic to a great extent, why it didn't happen in two constitutions in many other colonies. Singapore doesn't have many coups, doesn't have many constitutions, not Malaysia, not even India. So what makes the Thai constitution in Thai mixed legal system different from constitutions in many other countries, post-colonial country, with a mixed legal system as well? Or the Thai just mix more, too much? I don't know. This is the first set of questions. Or possible, the issue is not just a mixed legal system, even though I still believe that the relevance of the book in that direction is worth exploration. But perhaps the fact that the Thai constitution is much less stable depends on other factors. This book, I would say, in the story, you talk a lot more about other factors beyond the legal factors, such as politics. But when you say that constitutional monarchy is under theorized to try to do it, I would say bricolage or colonial legal system is also under theorized. I like Andrew's ideas about constitutional. He mentioned earlier. I like to look at that. But perhaps in this case, in the Thai case, perhaps other cases as well, I don't know enough. There are other factors that you didn't discuss much in the book. This brings me to the second set of questions. I would say when I read it, I love the method of layer of description. Yet, this method doesn't convey or doesn't help me. I can see difference of 3 levels, but it doesn't help me much to see the big picture or put the constitution battles into big perspective. I try to draw from the 3 layers of description, but I can't get that much. Instead, if I think like Andrew suggested earlier, what is constitution? What is constitution in the Thai sense? It brings me back to one scholarly debate in the Thai case that Eugénie didn't discuss much. You mentioned it and put it aside in the introduction. The notion that Andrew mentioned a moment ago, perhaps the paper constitution doesn't say much or doesn't cover all the Thai mean, what it means for constitution in the Thai context. So Thai scholars have suggested cultural constitution, have suggested the monarchy as a constitution, so on and so forth. That would bring the notion of constitution wider than the text. Okay, again, I look at the 3 layers. I am interested. And I think I still have to think about it a little bit more. But for me, I'm still left with lots of details, under theorized, put it that way, or under analyzed, to put in bigger perspective. But it brings me back to Andrew's point a moment ago that perhaps the Constitution, we have to look beyond the Constitution. In this case, Eugénie also explained, tells a lot of stories, and we can in a way we can derive at the somewhat conclusion by ourselves. The monarchy is one of the key factor in the Thai constitution. In this case, Thai scholars have suggested call it cultural constitution, but Eugénie didn't engage as much with this directly. You mentioned it, you cover it in the story, but if you engage with it, what it means, to what extent, perhaps we can see the bigger picture of the whole thing. And Andrew suggests one way to look at what are the constant issues that remains under these constitutions over 80 years. He found emergency power. I like that very much. I am working on that emergency or state of exception. It's amazing to me too. And if you look at chronology, the emergence of emergency or martial laws in Thailand is about the same time that you cover in this book. Somehow you have constitutional bricolage changed so much. You have the martial law and emergency law that hardly changed over 80, 90 years. Another way to look at, instead of, I wouldn't say that method Andrew suggests is wrong. No, I'm very interested, but I'm still exploring. Another way is that, how about look at all the elements, all the changes in the constitutions, so many constitutions in the story that Eugénie explained. Just break it down into what are the issues, such as upper house appointed or elected, the king's power to veto, so on and so forth. Dump all together, dump it all, put in different cards and dump them all together. Maybe doing that way, you see what is Thai constitution. Doing that way, you can see the perimeter, what Thai constitution cares. Okay, The third way is back to the cultural constitution. When I say it's under-theorized, because when I read the story, I'm eager to see how to understand the bigger picture, the overall picture. I don't mean that you can finish analysis, but let's at least see the scope, see the big picture, what they're talking about. To see the bricolage is one thing, it's helpful, but I want maybe old-fashioned. I want to see the big picture, the frame that help me understand different pieces, that help me understand why the bricolage. It seems like they improvise, but maybe old-fashioned in the sense that I want to see the big picture, the big factors that, how to say, that leads people to bring in those elements. And those elements, as I said, over 80, 90 years, the struggle about what are the issues that the constitution keep changing and keep returning, keep changing, keep returning. Most issues remain the same. Most elements of changes in those constitutions remain the same. So there must be something bigger than that, that somehow didn't really change all the elements, all the issues in those constitutions. Yet there's still struggle. There's still struggling how to shape power relations in this country. So I would say that I would say that my comment is that if there are somehow the big frame that help us understand the constitutional bricolage in perspective in 80, 90 years, that part is still under-analyzed, under-theorized. And I don't mean to devalue the book. It helps me think a lot. And I think that's how it works, and help me think big. I have to say, help me think big. In every direction, from Buddhist rationalism, secularization, to the other way, which is politics. Today's politics. It helped me think big, and I end up with all of these questions. And I think that if not helpful, at least I'm glad that I am trying to confuse you as much as I am confused now.
Thank you, Professor Thongchai. That's really great. We have 4 really excellent comments, in my opinion, and it's also helped me to think about some of the issues that I encountered or that I thought about when I was reading this book, Eugénie. So thank you to all our discussants for that. Eugénie, before I turn over the proceedings to you for your response, there are a couple of questions here that I want to bring to your attention, and they somewhat relate to all the comments that have been produced so far. So one question from Wirada Selim here is whether from this book that you have written, whether there are any implications that you have found that could shed light on how Thailand could move forward, especially in light of the ongoing political unrest in the country. Yeah, so just to kick off our final response and answer session with that. Eugénie?
So first of all, thank you so much for your comments and for your congratulations and your various points. I have so many things to tell, but we have very limited time. So I think I'll just first of all mention that I went way beyond the word count for this book, and the publisher was not that happy. So I had to trim down as much as possible. And that's one reason why so many ideas that I have are left not fully explicited, but I think I put them here and I leave it to the reader to get my point, even though I didn't really flesh it out completely, because for the reason of the word count that needs to be down. And the same goes for the critical part about the king's role in the Thai polity. So I didn't explicitly flesh out how the role of the king can be criticized in light of democratic development and so on, because I leave it to the reader to gather that criticism from the various details that I give in the various elements. I think one question that you all have is whether the Thai case is unique or whether it's common. And my point in this book is perhaps a point that you will be dissatisfied with, is to say the Thai case is not that unique. Bricolage happens all the time, everywhere. Abusive constitutional borrowing is the very way borrowing works everywhere. The cultural constitution is everywhere in the world. So everywhere is a constitution works by informal means, and what there is in the constitution doesn't tell the whole story. So I see a lot of commonalities, but I would say obviously the popular point about Thailand is that indeed there are these various influences from common law country, from civil law country, and from Buddhism that create some peculiarities. So for instance, looking at the constitutional court, so you have this influence from American type of judicial activism that is married with the Buddhist idea of the king, and also you have a very strong civil law system with a court that is a civil law type of court, and that creates altogether this type of juristocracy under royal commands that I tried to describe. The second thing that Khemthong pointed out that I think is particular to Thailand is how a handful of jurists dictate the narrative. So that's also one thing that I wanted to highlight, is how concentrated the legal knowledge, how concentrated the legal community is, and therefore how little contested the legal knowledge is in Thailand, because of that very high concentration of a handful of jurists who have driven the narrative and the doctrinal interpretation of what the constitution is in Thailand for so long. And that's why I put the appendix to show that there are only a few names, and these people all from the same background with the same type of personal history have been driving that narrative, and indeed they've always relied on the same British jurists to drive that narrative. And also about martial law, the fact that martial law pre-exists constitutions is also something that is common to most polities around the world, and that's also a very interesting point that is not unique to Thailand. And about the role of the monarchy, to answer to Tom's directly. So my point, my aim in that book was not to look at the social functions of the monarchy. I would have needed much more word count for this. So really my point was to answer the question, is Thailand a constitutional monarchy? But I really like your point about the crisis insurance function of the Thai monarch. And this is also an idea that I try to push forward in my chapters about juristocracy, showing how the function of the constitutional court, which is to guard against constitutional crisis, is the royal function, in fact, and how these functions have been pushed to the court by the king himself, even though, of course, he always retained the upper hand. Now, answering the questions from the audience. Well, the 2020, I end the book on the 2020 protest, which I had the chance to observe, thanks to Kals once again. So thank you again for that. And it really brings a sort of closure to this idea of is Thailand a constitutional monarchy, and to my argument in general, in that it was really one main argument of the Thai protesters that they needed a constitutional reform in order to move forward with democracy in the country. So they really saw that the problem did not come from the military, but rather from the king, and that from the question of the king, all the other issues of the military, of the role of anti-democratic forces in the Thai system derived from the role of the monarchy. And so what are the possible resolutions? This is something pointed out by Andrew Harding. On that note, I want to say that I believe King Vajiralongkorn is really replicating what his father has done before him in the 50s. So I believe he's really using the law, the means that he has in his power to strengthen and consolidate his rule. And I don't believe that he has made so many unwise moves so far.
I think the last sort of comment you made really speaks to the question from, I think, Peter Vale about how the current monarch engages with the Constitution today. There are also other couple of questions about engagement with other scholarship, for example, on judicialization of politics and Kopkwa Suwanatat Pian's book on kings, country, and constitutions. Unfortunately, we do not have time to directly deal with all these questions in this session today, but perhaps Eugénie can earmark them for further engagement with the people who asked these questions. That's it for our 19th session of the viral series. Thank you again, Eugénie. Congratulations, many congratulations for this wonderful book, and also to our 4 discussants for your rich critique and comments, which I believe will spur more scholarship on either monarchies in general or on Thailand constitutional law. Thank you very much for joining us, everyone.